Morning, Lieutenant.
Morning.
Lieutenant, you are the OIC of the Police Academy?
I'm the OIC of the training center.
And as part of your functions, are officers instructed on various laws?
Yes.
Including the law on the right and duty to make arrests?
Yes.
What probable cause is?
Yes.
Do you try to instruct officers on a yearly basis as to what the law is?
Yes.
And there is required training from the Ohio Police Officer Training Council on the use of force, correct?
I don't believe they have dictated training on the use of force. They dictate requalification with weapons.
Okay. And as part of that, the division then instructs on the use of force, correct?
Yes.
And also the laws with respect to the use of force?
Yes.
Are officers instructed that there are certain policies and procedures of the city of Cleveland relative to the appropriate use of force?
Yes.
And that force can be, back in 2012, called either deadly force or non-deadly force, correct?
Correct.
And are officers further trained that pursuant to law, if they violate any of the division's policies on use of force, they're subject to discipline?
Yes.
And I think you said in your testimony that the violation of these rules and regulations, although officers could be disciplined, the standard in the law is what the Constitution provides, right?
Correct.
And what the Constitution provides is as determined by the courts of this time, correct?
Yes.
So would you agree with the statement of law, and have you ever heard of this principle? The failure to follow a pursuit policy may result in internal discipline for the police officer, but it does not determine the constitutional test of whether the police used reasonable force when seizing fleeing suspects.
I've heard that before.
And that's in the, have you ever heard the Smith versus Freeland case?
Objection.
Based on?
He's not the person to ask this question.
Well, you've set him up as the person versed in policies and procedures of the department, and as the person who says underlying it all is the Constitution. So I don't. Plus, it's cross-exam, so the objection is overruled.
Can you ask that again, please?
Have you heard that case, the Smith versus Freeland case?
I don't recognize the title.
Okay. But you agree that, or you stated, I think, in your answer to my prior question, that you are familiar with the principle that a violation of a rule or regulation does not equate to a constitutional violation in terms of using excessive force.
Objection.
Overruled.
I've heard that. I've read that. Yes.
Okay. So in other words, to use the city use of force policy, it has a prohibition about reaching into a car to try to shut off the engine, correct?
Correct.
An officer should not do that, right?
Correct.
And would it basically be because that's an officer's safety issue?
I don't know the reasoning behind the policy, but yes,
Okay.
I think that sounds reasonable.
So let's say in a hypothetical situation, an officer reaches in after a lawful traffic stop and tries to shut off the person's car, and the person engages in conduct which then lawfully justifies the force that the officer uses. Okay? Does the fact that the officer reached in to shut the engine off make the use of force unlawful?
No.
So the violation of policies and procedures is not the standard for whether or not there's an excessive use of force, correct?
Correct.
It's a question of law.
Yes.
Now, you indicated, Lieutenant, that the pursuit in this case involved up to approximately 60 cars, correct?
That's what I was told. Yes.
And that was, you can't remember a pursuit of that magnitude, correct?
Not that I remember.
You recall one you had with like 10 or 20 cars, correct?
Correct.
And the pursuit in this case happened November 29, 2012, correct?
Yes.
Do you remember a couple months later in January 2013, Officer Taylor was shot in the chest. His bulletproof vest saved him, and there was a response of about 70 to 80.
Objection.
Well, you had him testify on direct to his experience in chases, to this one, the one that's this lawsuit is centered on, being the biggest one he's ever heard of. You had him testify that 10, I thought he said 10 to 15, but in the, let's say in the teens was his personal, was the largest one he had personal experience with. So this is proper cross-examination.
Judge, I would agree, but not getting into the facts of the case. I didn't get into the facts of the case of these other chases that he was involved in. Mr. D'Angelo is.
But you're getting into the question of the biggest.
Right, and that's, I have no objection to that. He started talking about the facts of that case, why the chase was.
Well,
And I think it's irrelevant and not germane to the issues here. Thank you.
it may be irrelevant whether he was ever in a chase of 10 to 15 or whether he's ever heard of a chase of 70 or
Right.
60.
Right.
But you asked it, it was not objected to, it's now in evidence. And I suppose I could have objected to it myself when you said, is this the biggest chase you've ever heard of? I guess I would call this opening the door. So the question was, officer, did you hear, are you aware of a chase that involved around 70 cars after a fellow officer was shot?
I'm aware of the incident. I don't recall the number of cars. I'll call that.
I recall that there was a large response throughout the various districts in the city of Cleveland to that location.
Yeah, I remember reading that in the news.
Lieutenant, let's just go back to the use of City of Cleveland use of force policy in effect on November 29, 2012. You're aware of the fact, are you not, Lieutenant, that these are orders from the Chief of Police and all officers are subject to obeying these, correct?
Correct.
And as part of the procedures of the City of Cleveland, the City of Cleveland Law Department is involved in reviewing these, correct?
Yes.
And there's a number of reasons associated with that, but one of them also includes legal liability of the city, correct?
I believe so, yes.
Okay. So if you could refer to the very first page, it starts off with what the purpose of the policy is, correct?
Yes.
And then there's a policy statement, correct?
Correct.
And then on page 2, it continues with definitions.
Yes.
And if you go to procedures, Roman numeral 1, capital letter A, it has force level, correct?
Yes.
And could you read what it says in section A?
Including the subsections?
Pardon me?
You want me to include the subsections as well?
No, let's just read the section A.
It says, members shall determine the level of force necessary to protect themselves or others, or gain compliance from combative, resistant, or violent individuals. Members shall consider alternative tactics to the use of force, which include but are not limited to
And well, you can read 1, 2, and 3.
concealment and or cover, voice commands, show of force, for example, multiple officers, alternative weapons.
Okay. But under section A, it's a fact, is it not, that the word member refers to Cleveland patrol officers, correct?
Yes.
And that would also include supervisory personnel?
Yes.
And that supervisory personnel would have the rank of sergeant on up, correct?
Correct.
So it's the individual officer that makes the determination on the spot when things happen, correct?
Correct.
So you have your training, but an officer, before they make a decision to use force, they're not required to get on the radio and call this sergeant and ask for permission to use force, correct?
Correct.
The next section, B, that's the action response continuum, correct?
Yes.
And I think you testified as to some criticisms of this continuum because it appears to be rigid and the division does not want to have officers kind of hamstrung by just going from one color to the next.
I believe it has been removed due to it causes confusion and it's the rigidity behind it.
Okay. If you could read the paragraph right under action response continuum.
Members are prepared with knowledge of laws, proper training in non-deadly force, proper training in use of force decision-making, proper training and accountability to high ethical standards, and an understanding of division directives. The action response continuum suggests a member's response to a suspect's action. It does not require proceeding in a certain order.
So again, the force levels are suggestions, and it's up to the judgment of the individual officer as to what the appropriate action is, correct?
Yes.
And there's no requirement that an officer start off at blue, then go to green, then go to yellow, then go to orange, because something can start off at blue and then all of a sudden require that you jump up to the red level, correct?
Correct.
I think Mr. Gutierrez acknowledged, and I think your testimony was to the effect that the events that transpire where officers have to resort to using force are unpredictable in nature and they can rapidly unfold, correct?
I would say that in many cases they're unpredictable,
Okay.
but they do rapidly unfold usually, yes.
And they can be very fluid, correct?
Yes.
I may have one moment, Your Honor.
Sure.
Now, with respect to the use of force, you would agree, would you not, that when looking at the officer's response, the division tries to look at things and the law requires that you look at the circumstances and make an allowance for the fact that these are dangerous matters, that they sometimes unfold very quickly, correct?
Yes.
And you don't use, although you have the benefit of 20/20 hindsight, you try to put yourselves in the officer's shoes or an objectively reasonable officer as he or she had to make judgments when dealing with the threat that they faced, correct?
Correct.
Now, we spoke about traffic stops. You would agree that a very minor traffic stop can all of a sudden escalate to a deadly force incident, correct?
Yes.
An individual can be stopped for a minor misdemeanor, and all of a sudden an officer's life is in danger, correct?
Yes.
In fact, aren't traffic stops one of the most dangerous job functions that an officer performs?
They're dangerous. I don't know if most dangerous is.
Well, in terms of the incidents of deadly force incidents involving officer fatalities, don't traffic stops rank right up there at the top?
They're significant. I don't know the exact numbers.
And we've had Cleveland police officers killed after making simple traffic stops for minor misdemeanors, correct?
Yes.
Officer Wayne Leon was killed by Queasy Bryant for a minor misdemeanor traffic stop, correct?
Objection.
Well, the point has been made, but overruled. I mean, it's cross-examined.
I don't remember what initiated that contact with him, but
He pulled up to Mr. Bryant with a gas
Well,
mask.
here, we're not going to
Okay.
litigate that case, but
That's fine.
the point has been made.
And in the city of Cleveland, are officers confronted with suspects who have access and use dangerous automatic weapons?
yes,
AK-47s and the like?
I've seen them, yes.
And in today's world, are you familiar with incidences where police officers in uniform are executed simply because they're a cop.
Yes,
We've had a recent 2 officers killed in New York, correct?
yes,
We had an officer killed in Las Vegas having lunch with another officer, just gunned down,
yes,
because they had a uniform on. Recall that case?
yes, I do.
And we go around the country, but is that an ever-present fear in today's world that officers have?
They should be mindful of that and prepared, yes.
And would it be a fair statement that you never know who you're dealing with or what you have until you really get into the situation?
Yes, you have to be prepared for anything.
When you testified, Lieutenant, that you worked on the road as a patrol officer for approximately 10 years, you would have the occasion to get to know some of your coworkers, correct?
Yes,
And like any other employment arena, police officers come in all shapes, sizes, and colors, and backgrounds, and personalities, and temperaments, correct?
correct.
And there's some that are recognized as hard workers, and others that do their job, but they're not going to write up a bunch of tickets and arrest a bunch of people. They're just going to try to start their shift and finish it and go home safe, right?
That's fair, yes.
Okay. Now, when you were working on the road as a police officer, if you heard a broadcast from an officer that you respected, and the officer was broadcasting that someone had just fired a gun in his or her direction, would you attach credibility to that
Objection, Judge.
broadcast?
That is not what that officer testified to. That is not what the broadcast was. He said never said he was shot at.
The word objection is fine, and it is indeed sustained. I mean,
If you heard a broadcast from an officer, whatever it might be, that you believe was significant or dangerous, would you attach credence to the broadcast because of who it was that made the broadcast?
Yes,
Okay? So if an officer were to testify that you respected that a round was popped off as a car drove by his location, would you think that that officer was just making that up?
Objection.
well, let me ask the opposite of the second last question you answered. If an officer that you didn't think amounted to much, that you didn't much respect or didn't think was a particularly capable officer, sends out a broadcast, would you ignore him or her?
no, I would not.
I think we can go on to the next subject.
Okay. And when police officers use police radio, is there a concern that you don't take up valuable airtime?
Yes,
And if an officer were to say these words in the course of a police chase, what would this mean to you? Let me stay on the air.
it means if you don't have necessary traffic for the radio, don't key up.
Okay. So let's say that in this particular case, Officer Seifer was in the lead car and he was broadcasting to other officers the various locations and what his significant observations were. If Officer Seifer were to broadcast, let me stay on the air, and you were another officer in the pursuit, what would you interpret that to mean?
It would mean don't run, don't key up, don't interrupt his traffic. He's got important information.
Right. Don't interrupt me. I got this. You can tell I'm broadcasting. If you interfere and chime in on the radio, I'm not going to be able to broadcast, and you're going to run over what I'm trying to say, correct?
Sure, yes.
And critical information may not get out to other officers, correct?
Right.
And that's an issue that comes up in pursuits that I think you spoke about in your testimony, correct?
Yes,
Mr. Gutierrez went through the pursuit policy with you and different scenarios. and I think it would be a fair statement, would it not, that the execution of a pursuit can be a very complicated matter.
Yes, they're difficult to manage.
And I think it's clear, but your testimony was that in 2012, during the relevant time periods that this pursuit took place, the Division of Police was not instructing its officers in its annual in-service training on techniques and the rules on pursuits.
Not an in-service, no.
Okay. And if there was any training that officers would receive on an annual basis, it would vary depending on who his or her supervisor was, correct?
The in-service training was standard. Anything additional to that would be either training that they would seek out on their own or training that their supervisors would give them.
Right. But the annual in-service training, the pursuit policy was not trained in 2012 as part of the in-service training, correct?
Correct.
Okay. So in 2012, the officers in the city of Cleveland that responded to this pursuit were not getting any annual training on the techniques and the policies of the division on pursuits, correct?
Other than what their supervisor should have been
Right.
providing them. Correct.
I was speaking to in-service.
Correct.
Okay. So the only training they would get would be whatever a supervisor would give them, correct?
Correct.
And that then could vary from shift to shift, from boss to boss, from district to district, correct?
Yes.
Would it be a fair statement from your testimony and from your experience in the division that the practice and policy were different in the Division of Police on the subject of pursuits in the year 2012?
In my experiences, yes, occasionally.
Okay. Occasionally, or?
Not all the time. I mean,
Okay.
nothing was, I mean, there were times when it followed policy perfectly and
Okay.
other times when it did not.
All right. Now, again, in answer to a couple questions Mr. Gutierrez posed, Lieutenant, I think you did acknowledge that there are some officers, when they hear a pursuit, that they want to respond to that type of a call, correct?
Yes.
Would you agree, though, that there are also officers who want to respond to that out of a sense of duty?
Oh, absolutely, yes.
Okay. Well, when you said that there are officers in the other category that they get charged up over this or whatever, I want to make sure that I clearly understand what your testimony was. So why don't you say it rather than me suggest it?
Well, I'm not suggesting that officers are jumping into pursuits because it's thrilling. I would say it's more of it's our duty to get involved. It's our duty to fulfill this mission. And, is it exciting? Yeah, absolutely it's exciting. There's also a sense of duty there.
Okay. All of you that work for the City of Cleveland and Division of Police, you're professionals, correct?
Yes.
You take an oath of office, correct?
Yes, we do.
You take pride in your work?
Absolutely.
Do you believe in the motto serving and protecting?
Yes, I do.
Do you believe the members of the rank and file members of the Division of Police feel the same way?
Yes, I do.
And when a broadcast comes out over radio that's dangerous and it calls for police service, do police officers respond out of a sense of duty?
Yes.
Let me ask you this. Do you know a pretty good amount of the police officers who responded to this incident?
I know some of them very well. Some of them, it's a wide range.
Okay. Can you give us just a rough guess? There may have been 60 officers, 100 officers or so that responded. Do you have any rough ideas to approximately how many of them that you know or were aware of that responded in this manner?
I'm probably aware of most of them.
Okay.
And know a good percentage of them
Okay.
pretty well.
Generally speaking, is it your belief that they were responding in good faith?
Yes.
and they were responding out of a sense of duty?
Yes.
You also went through the pursuit policy with Mr. Gutierrez. Would it be a fair statement that the policy as it existed in 2012, beyond the lack of training issue, it was also in part vague?
Yes.
And it also differed from the practice from district to district, correct? In its implementation.
I can't really speak to only to my experiences.
Okay.
You know.
But your experiences were that the city's policy on pursuits versus the practice as to how it really works in the real world significantly diverged from one another, correct?
I don't know if I would use the term significantly, but at times it would diverge. Yes.
And when it would diverge, would those be in out-of-control cowboy-type situations or men and women responding and trying to do the best they could because they felt a police response was appropriate?
Objection.
Sustained.
In this particular case, the pursuit began, or when it was first called on the air, the second district had control of it. Are you aware of that?
Yes.
Okay. And the pursuit then went throughout the city of Cleveland. A number of districts, I think, came close or got into the first and went back to the second, then maybe through portions of the third, and then out to the fifth district, and then ultimately into East Cleveland. Is it your testimony that the sector supervisor of the second district was the supervisor in charge of this pursuit?
I don't know if those facts for that pursuit, but according to policy, the sector supervisor should have been in charge of that pursuit.
Okay. So if this pursuit in part got close to or was about to go into the first district, and a first district supervisor was hearing all the radio traffic and terminated any first district cars, would that termination obligate second district officers in the pursuit to terminate?
No.
That would just be an order from a first district boss that, for whatever his or her reasons were, we don't need to get involved with it because the second district's got it covered, correct?
The first district boss would have control of their cars.
Okay. And then when it went through the other districts, as in the third district, we have the downtown services unit. So when the DSU supervisor terminated the pursuit, who would that order apply to?
In my opinion, the cars that respond to them.
And that would be third district DSU officers, correct?
Correct.
And when a third district sector supervisor terminated the pursuit, who would that order apply to?
Objection.
Overruled.
Ask again, please.
When a third district sector supervisor terminated the pursuit, who would that order apply to?
In my experience, it's third district
Okay.
cars.
And when the pursuit went out to the fifth district, when a fifth district boss terminated the pursuit, who would that order apply to?
The same, fifth district.
Fifth district personnel? And the rationale for each boss's order to terminate would speak for itself depending on what that supervisor had to say why he or she ordered their troops to terminate, correct?
It would be their decision to make for whatever
Okay.
reason.
From your experience, would one of the reasons to terminate by one of those other district supervisors be that from reviewing what they were hearing on the radio, they felt that there was a second district supervisor in charge, and that's the person that's going to handle this?
Objection.
From your experience.
Well, sustained. He's already testified that in his experience, when a supervisor makes a decision, they have reasons for it.
Okay. Just if we could touch briefly on this term that you testified to, Cleveland Rush. Again, in your own words, describe what you meant by that term.
I believe that term originated, being assigned new to the training section, we sat down and one of the things we talked about is how can we make what we're training here have legs and be implemented in the division. And one of the things we looked at were felony traffic stops. We had taught felony traffic stops in service year after year. I mean, I think we did it 2 or 3 years in a row, around 2010 to 13. But we're teaching felony traffic stops, but in my experiences, we weren't seeing them always performed in the field. And there was frustration with that. It's like, why we still have officers rushing up to a car in a felony traffic stop situation when they shouldn't have been. So I think we coined that the Cleveland Rush, and that's how that terminology, I believe, came about.
And that's a tactical concern based on officer safety issues, correct?
Yes.
And in those types of incidences where Cleveland officers would rush a car in a felony traffic stop, would they in fact rush the car because they wanted to get the jump on the person inside so that they could have control over the person in the car?
That's one of the reasons I've heard, yes.
Okay. Are there any other reasons?
I think people want to be up front, taking control.
Okay.
You know, they want to be the ones up there, hands-on, making sure that things are going. You know, they want to be in control of that situation. I'm taking ownership of it. Whatever the reasons might be.
Okay. And the division's position relative to that is, listen, we want to do it and go about it differently because if you run up on a car like that, the suspect may be armed and you can get shot and you're kind of rushing into danger, correct?
Yes.
So tactically there's a better way to go about it, right?
That's what we believe, yes.
But those officers that have been using the tactic of rushing the vehicle, to your experience, were they doing it because they were out of control cowboys?
Objection.
Overruled.
I don't think it was because they were out of control. Yeah, I don't think it was because they're out of control.
They were trying to do their job and they felt this was the way to get the bad guy by getting the jump on him, right?
Just one.
Sustained.
You gave some testimony about flanking and also engaging, correct?
Yes.
So there are times where you have to leave harm's way because of the officer's assessment of the situation, correct?
Ask that again.
Well, are there times when an officer would leave cover because the officer feels that it's appropriate and necessary relative to the dangers that they're confronting?
Yes.
And would the same thing apply to an officer leaving a cover position?
Yes.
That an officer sometimes leaves cover because of a duty to apprehend, and also the officer makes a snap decision that that's the best tactical move to make.
Objection.
Overruled, although the question has been answered. But go ahead.
The officer, that can be a reason that they would leave cover, yes.
Okay. Approach, Ryan.
Sure.
Lieutenant, showing you what's been marked as Defendant's Exhibit B, could you please identify that?
This is our active shooter response policy.
And is that the policy that you were referring to previously in your direct examination?
I was referring to the training, not
Okay.
necessarily the policy. But
All right, but that is the policy, correct?
yes.
And does the policy provide that officers may respond in that fashion to an active shooter, and an active shooter is defined, correct?
Active shooter is defined in here, yes.
Okay. And that's not only, the definition includes not only an individual who is actively engaged in shooting, but one who the officers believe is attempting to, correct?
I'm going to need to refer to that.
Yeah, sure.
Take a look at it real quick. Can you ask the question one more time, please?
The definition of active shooter includes not only a shooter who is actually shooting, but one who is attempting or is a risk of serious physical harm to the public.
Yes.
Okay.
That is in the policy.
Now, would an individual who is being pursued for felonious assault on a police officer be an individual who would be deemed to attempting to inflict serious physical harm on an officer or
Objection.
in fact?
No, overruled.
May we be heard, Judge?
Judge, Your Honor, I object to like the
You're
5
right,
or 6
right,
different
right.
prosecutors.
I'm either right or wrong. I think I'm right. If I'm wrong, it will be corrected. So
Well, all I
the
ask is if we could
objection's overruled. You've made
explain our
your,
objection, that's all.
you've protected your record.
We don't have any rights, Judge. It's a state, we don't have a right. If we lose the case, the
Objection to
appeal
that.
is gone. We don't have a right.
State your
The rights are theirs on appeal. We have no appellate right. If you find this man not guilty, there's nothing we can do. Absolutely nothing. That's why I wanted to explain the false premise of his question. So it's a false premise. You can't ask a question on a false premise.
Your Honor,
Well, we don't have all the evidence yet. We do have some evidence about why Officer Nan began the pursuit. So I disagree.
And he's not felonious assault, popping around, not at someone. There's no evidence he popped around at anyone. You said he popped around. That is not felonious assault of a police officer.
Right, well, it is, well, if I recall Officer Nan's testimony correctly, he felt he might have been being shot at, but not only that, it is, as Mr. Shaughnessy pointed out, at a minimum discharge of a firearm over a public roadway or something to that effect. So, and by the way,
It's not felonious assault, though.
well,
It's a misdemeanor.
but he can ask a question, especially on cross-examination, any way he wants, and then you can, on redirect, you can come in and point out that there was no suspicion of felonious assault on a peace officer. So that in fact is part of redirect.
We remove any objection to a hypothetical.
Your Honor, just note our objection to not one prosecutor handling an examination of a witness and speaking objections and disrespectful conduct towards the court in talking over you and your rulings. We don't feel that's appropriate.
This is the guy, coming from,
Please,
the guy
please,
did
please.
the slander on his court last fall in the paper, and his motion to the Supreme Court, and he's accused of me being disrespectful to this court. I have great respect for this court. I've announced that in every time I've spoken. I think that this court is a highly capable, ethical court, and I've never suggested otherwise, as he did in his motion to the Supreme Court and publicly. So coming from him, that's ironic.
I would say this, if a party objects, please try to keep it to object or objection. As I've said before, if I don't believe I know why you're objecting, I'll ask for a further explanation. I'm grateful for your comments. By the same token, I can shrug off the criticism as well. Let's focus on what the evidence is or is not. So, the essence of the question is, again, Mr. D'Angelo?
if officers are pursuing an individual who is alleged to have committed a felonious assault on a police officer, where that person is alleged to have fired a weapon at a police officer, would that fall within the active shooter definition?
It's close. I would say yes. The definition says that is causing or attempting to cause immediate death or physical harm.
Okay.
I think it's an immediate action.
Judge, here's a document that he's going to be sent to the witness, I believe, is the police reports of this incident.
Okay.
I would object to it because this officer doesn't know the facts and circumstances of this incident, and to try to now give him these facts and circumstances would be inappropriate.
Well, if I correctly understand the main purpose of this witness testifying, it's to outline essentially what is and is not acceptable procedure for a pursuit as of 2012. So he can show him anything he wants and ask a question. So let's, at least you've alerted me to the possibility that something objectionable is coming. But as of right now, I haven't heard a question.
Thank you, Your Honor.
Well, we'd like a moment to read what it is. But I've never seen these before.
You don't know what's on your portal?
I haven't seen
Well,
what you
here.
put in front of us. These are not the police reports.
No, hold-
I can't read
Actually,
50 pages in
hold on.
5 seconds. I don't know what they are. The Cleveland police didn't do an investigation on a criminal investigation on this
He wants to
case.
give a speech, Your Honor.
Hold on, because you're speaking of protecting the record. It is very difficult, although I've never done the job, for Ms. Schuler to take down one or two or three people speaking at once. So you propose to what? Point to a particular portion of this police report and ask this witness a question or two?
Yes.
That looks like it's 20, 30 pages. Do you know what pages it'd be talking about?
The first
Can you tell your opponent that?
Your Honor, it will be in summary fashion, not to narrate the contents of what's in the report or to go through the incident, but just to identify the document. I will represent to the court that this is a Cleveland Division of Police field report relative to this incident, as prepared by Lieutenant Tim of the Homicide Unit, and an associated report presented to the Chief of Police, Michael McGrath, relative to this incident. And I'm offering it for the purpose of evidencing and following up on the questions related to an active shooter situation.
So the notion is you're going to ask him to look at certain portions of the report, and then assuming what's described there is accurate, does it or does it not fit within the active shooter description we've already heard?
Yes, Your Honor. Now, I'll proffer to the court. So if you want me to...
May I interrupt? Because here's I think is a better way to do this. I've heard the testimony about what the policy is. I've heard the testimony about the definition of an active shooter. To the extent it matters, I think I could decide for myself as the evidence comes in whether the situation that presented itself on November 29th was one of quote-unquote an active shooter.
Your Honor, if I may, the reason for the question is that this report designates 28 victim officers under the category felonious assault on a police officer, failure to comply, and the suspects are Malissa Williams and Mr. Russell. It's an official Cleveland police document. I wanted the witness to identify it if he could. That's the basis for the question.
Well, it doesn't make it admissible, but here, I'm not certain this needs to come in at all, but I don't know that this is the correct witness for it. Why don't you wait until you have a witness who was part of that investigation? So why don't we hold off for now?
Okay, very well, Your Honor.
And actually, while we're in a kind of a lull here, do you have an estimate?
I should be done, I don't think any more than 15 minutes, probably less than that, Your Honor.
I gather there's going to be some redirect, and I have a couple of questions. My intent was, Mr. McGinty, to go off the record at 12:15. It sounds like this witness is going to be done sometime around 11:45. Who's your next proposed witness?
We would be able to put somebody in that we would be able to take up that half an hour. Or
Okay.
less.
Okay, so if he or she is here, have them please stick around, and we'll at least get a few minutes of their testimony. And I think, back though to, although we probably need a little bit of a break. When did we start, Mary? 10:30? Have them around, and if we don't get to them this morning, then just tell them I apologize. But we should at least get in 10 to 15 minutes of their testimony.
Thank you, Ryan.
So back to the cross-examination.
Thank you.
Lieutenant, if we can go back to the use of force policy for a second. In the training in the police academy on not only the policy but also the various factors that officers deal with in using force, is there a principle called action and reaction?
We're calling action response.
Yes.
So we're responding to a suspect's actions.
Okay. And because you're responding as a law enforcement official to a subject's actions, so you're responding to their actions, is there a principle that's trained to the officers relative to how you're normally reacting, so you're behind the curve, so to speak?
There is a reaction delay, yes, we trained
Okay.
that.
And could you please explain to the court what that is?
I don't personally teach this, so I'm not as knowledgeable maybe as others in this matter, but the basic concept being that the time it takes to observe an action, process it, and respond to it, there's just a natural delay there. There's not an instant response. There's always going to be a delay.
So in these dangerous encounters, officers are normally behind the curve because they're responding to the individual they're dealing with, correct?
Yes, they're often behind the curve, and we try to train to limit that curve as much as possible.
Okay. And there are also officer perception issues that come up when making judgments as to what's the appropriate use of force or the response to make, correct?
Can you ask that again, please?
Are there also perception issues that officers have? In other words, what are they perceiving when they have to deal with an incident that's very fluid?
Perceptions are they're variable.
Okay. So, and they're very, circumstances are very unpredictable, correct?
Yes.
So if you can envision, as in this case, Officer Brelo and his partner, after about a 20-minute pursuit with the broadcasts that are a matter of record, pulls in, hearing shots are fired, and all of a sudden, as Officer Brelo is positioned in the parking lot.
Well, let's let him finish the question.
He's testifying.
This is, please. I'm pretty sure I know why you're objecting, but I'd like to let him finish the question. I have a feeling how I'm going to rule when you do object at the proper time. But let's hear the end of the question.
If I may, Lieutenant, If a police officer, as in this case, turns into a schoolyard in a city where he's not familiar with the exact location, and the subject makes a turn, shots are fired, and the suspect car then is trying to escape, and Officer Brelo's car is positioned, and the suspect car all of a sudden is nose to nose with his car about a foot away. Would that be something that happens unexpectedly?
Objection.
Sustained.
Would you fault an officer for turning into a schoolyard in the course of a pursuit, and unbeknownst to that officer, the suspect turns his vehicle in an effort to get out and all of a sudden is nose to nose with that officer? Does that officer intentionally make a wrongful tactical maneuver?
Objection.
Sustained. However, the very first part of that question, I think, is allowed, which is, would you find fault with an officer who pursues a car into a parking lot?
No.
As a general proposition.
No.
All right. Pardon my butting in there. Next question.
Would you agree that an officer in dealing with the situation may have actual knowledge of something? I'll withdraw that, Your Honor. We'll deal this with another witness, but I'll ask this question. And it goes back to the questions I asked before about violations of policies and procedures not being the same as a constitutional violation. Are you aware of, in this case, that a number of Cleveland police officers were disciplined for violating the pursuit policy and other policies?
Objection.
Overruled.
Yes, I'm aware of that.
Okay. And are you also aware of the fact that there were 12 officers who were not criminally charged with the use of deadly force in this case, who had used deadly force?
Yes, I'm aware of that.
Okay. And are you further aware that the county prosecutor has stated that those 12 officers did not violate the law in their use of deadly force?
Objection.
Well, I will say this. I don't know that the county prosecutor has said those particular words. You have into evidence the fact that 12 who used deadly force were not charged through this witness. It's probably sufficient at this point.
It's a foundational question, Your Honor, for my next question.
Well, then I have to ask Mr. Gutierrez, the objection is what? That the prosecutor's never said those exact words or some other objection?
It's a mischaracterization, Your Honor. What their actions were not indicted.
I said the use of deadly force, Judge.
That's the term, Judge, not indicted. What he's trying to do now is make him the use of force expert, Judge. He doesn't know the facts and circumstances of this case. It's not proper for him to be going through all these facts and circumstances. That will come later with our use of force expert. He's not in a position to opine as to who did what, when, and where, because he doesn't know the particular facts and circumstances. Mr. D'Angelo is trying to get him to be the force expert. So that's why this whole line of questioning, Judge, is really improper.
Well,
Your Honor, that's not my intention.
Hold on. I will say this. As a question by itself, the question, I think, is objectionable. To lay a foundation, it may not be, but what is it a foundation for?
My next question.
Which is,
are you aware of the fact that those alleged administrative rule violations relative to the pursuit policy and the Division of Cleveland's use of force policy has not then necessarily followed that they committed a crime in their use of deadly force in this case because they violated those other policies?
well, by the way, he's not asking it yet. He was, I think, telling me in response to my question what his question would be. I think, though, what you want to be in evidence is already in evidence, which is to say, if I understand your proposed question correctly, that an administrative violation does not necessarily equal a crime.
Correct. But I wanted to tie it in specifically to those 12 officers. We spoke about it in general terms, in terms of what the law is and what's trained in the academy.
Well, that's already in evidence, and I would say this. Is there any doubt that Katsaris is going to testify?
None whatsoever, Your Honor.
Going to be presented as a witness?
Absolutely.
That might be a question for him. Does he have knowledge about who was and wasn't administratively disciplined and why?
Generally, he knows that they were disciplined. I don't think he got into why. And again, that would be somewhat that they should bring in the City of Cleveland people who did or did not do the administrative proceedings.
Your Honor, I'm not duty-bound to accept anything relative to what they say as being accurate as to what they will do. And as was pointed out with the inquiry when we were dealing with any Fifth Amendment issue that came up in this court. So I have a right to ask this witness.
Well,
if you say it's objectionable, you're the judge.
Yeah,
But
I think for this witness, the objection is sustained.
Okay. Lieutenant, you spoke of the word tunnel vision before relative to the pursuit subject, correct?
Yes.
Is tunnel vision also a principle that relates to deadly force encounters?
Yes.
And that speaks to the human factors that officers go through when they're actually involved in a deadly force incident.
Yes.
And that's separate from the tunnel vision that may come up during the course of a pursuit.
I'm not all that familiar with the technicalities behind it, but I believe it's similar. I think it's a similar physiological response.
If an officer were to have tunnel vision in a pursuit that did not relate to any kind of deadly force, that would be something that happens just because of what is involved in a pursuit, correct?
Objection.
Overruled.
I believe that tunnel vision is a physiological response to stress.
Okay. And if you don't have a deadly force incident, but you have a pursuit, you testified on the culture questions that Mr. Gutierrez asked, that tunnel vision does come up sometimes in a pursuit.
Yes.
Correct? So I'm just simply asking, does tunnel vision come up in deadly force encounters? And your answer was yes, correct?
Yes.
And in that instance, though, that's separate from the tunnel vision experience that comes up in a pursuit where there's no deadly force involved.
Separate types of incidents, same physiological response.
Okay. Questions were asked about getting on a hood of a vehicle. Remember those questions?
Sure, yes.
Now, because deadly force encounters could happen in an unpredictable way, are you saying that it's absolutely inappropriate in any given set of circumstances for an officer in a deadly force incident to ever get on a hood of a car?
Anything's possible, I suppose.
Okay. And when a deadly force incident unfolds instantly right in front of you, Lieutenant, without any expectation on your part that it's about to happen, you have to react right away, correct?
Yes.
And what's your primary motivation at that point?
To stop the deadly encounter, to stop the deadly force being used against you or somebody else.
If someone's shooting at you, your object is not to get killed, right?
Yes.
And then to neutralize the threat, correct?
Yes.
And so if it happens unpredictably and you have to jump down a ravine, if you make that decision to jump down a ravine, you wouldn't train that, but just because you did it wouldn't make it wrong, correct?
Correct.
So you do what you have to do to survive, correct?
The best that you can, yes.
Have you ever had to fire this ambush training you spoke about, have you ever been involved in an incident where you and or your partner were seemingly trapped and you had to start firing through your windshield at an assailant?
Not personally, no.
Do you think that would be a pretty horrifying experience?
Yes.
What about the sound of firing a weapon inside a zone car with the windows up? Does it sound pretty deafening?
I have never fired from inside a car. I have fired in similar confined spaces, and it's bad.
It's bad?
Yes.
You made reference to an exhibit involving Officer Brelo and offered some testimony. Are you aware of the fact that letters of re-instruction are not discipline?
Yes.
And the exhibit that you made reference to, was that a non-disciplinary letter of re-instruction?
I don't recall exactly what that was. I don't recall exactly how we received that from the chief's office.
So you don't know the circumstances. It's only a one-way street with this side of the courtroom over here. You don't know anything about that case, but they want to and get to ask you questions about that. But I can't do it when it relates to official police reports. They can ask it about non-disciplinary matters, and it's okay.
Hold on. The underlying question is not objectionable, but it is similar to what you objected to from the other side, throwing in what I would call editorial comment. I mean, as I think I've said more than once, if I don't think I can sort out why testimony is being elicited or what is occurring here, then I will ask. But mostly I think that I can, and mostly I believe that I can ignore the outside stuff. So I guess the basic question is, you can't say exactly whether discipline resulted from that July 2012 incident.
Yeah, I don't recall.
Okay. Do you know that, in fact, Officer Brelo did not fire his weapon in that incident?
I'm fairly certain that was the case, yes.
Okay. Are you aware of the fact that his partner, in fact, had an accidental discharge of her weapon in that incident because the suspect put the car in reverse, hit their patrol car, and when she had her weapon out, when she was on the passenger side of the vehicle, her weapon went off accidentally? Are you aware of those facts?
Overruled.
I'm not aware of the facts specifically. Generally, that's how that's how I recall it being. Yes.
Vaguely, you recall that's what happened
Yes.
there?
Yes.
And if, as a result of that, Officer Brelo and his partner were given letters of re-instruction, they were simply not disciplined, but retrained on officer safety issues involving traffic stops like that.
Letters of re-instruction are not discipline.
Okay. And in that particular case, then you're not aware of the fact that there was a radio broadcast that they were responding to about a road rage incident and a potential gun involved?
I don't know.
He's welcome to ask, and he says he doesn't recall. So the evidence, there's no evidence then of the details of their incident giving rise to the re-instruction. There's no evidence.
The judge, he's testifying. What he's doing is
No, it's not.
It's called cross-examination.
Testimony is providing evidence.
I'm talking to the judge, Mr. James, and I'm asking.
Testimony is providing evidence. Now, you cannot imply in a question something that you know not to be true. So my expectation is that now that this has been made an issue for some reason, that some evidence may come in either supporting or not the hypothesized version of events.
No. Judge, you answered my question. Thank you very much.
Was Cynthia Moore his partner at the time? Or don't you recall?
I don't believe so, no.
Pardon my ignorance.
Officer Galazaro, does that ring a bell? This is partner. I think her name's on that.
Yes, Liz Galarza.
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 Lieutenant, when we spoke about pursuits before, and Mr. Gutierrez asked you about the policy and made reference to that map of the districts. In the radio dispatch center, are you aware of the fact that there's a large monitor that shows the cars and their AVLs as to where their location is?
Vaguely, yeah.
Okay. So that on November 29, 2012, in the City Cleveland Dispatch Center, there was a large monitor with all the cars depicted based on their AVLs, correct?
I'm not aware of that.
Okay. But you're aware that there's a system in place there?
I believe I've seen the video screens down there. I've only been down there a few times, but I'm not that familiar with it.
So you have no firsthand knowledge that such a device exists in radio dispatch?
No, I believe it does exist. I don't know the size. I don't know what it's
All right,
on
so
there.
what would be the purpose of such a device in radio dispatch?
For the AVL? Is that
Yes.
what are you asking
Yes.
exactly here? So that the dispatcher can know where the cars are, to help aiding in dispatch, or if there's an emergency situation, so that she knows where the cars are, he or she.
And is there a supervisor that's assigned to radio dispatch?
Yes, there
A
are.
Cleveland police supervisor?
There were at that time, yes.
Okay, and is there also a commander in charge of that unit?
Yes.
Now, among one of the other deficiencies in the pursuit policy of 2012, there was no system in place for a supervisor or a high-ranking police official to monitor a pursuit that lasts for a unusually long period of time and goes into various districts, correct?
There's nothing.
Pardon me?
Overruled. Go ahead.
There's nothing in the policy that speaks to that. No.
Okay. And in terms of good practice and best practices, in November 2012, there was no information transmitted from police dispatch that had a monitor showing the AVL to the supervisors in the field to give them information that they may not be aware of, correct?
Objection.
Well, it's not objectionable, but I have a feeling, based on what I've heard, that this witness wouldn't know, but so, the long and short, the objection is overruled, but are you able to answer this question?
I'm going to need you to ask that question again, so
Okay.
I know what you're getting at.
Would it be a fair statement that there was no information in this incident that was given from radio dispatch to the supervisors in the field about the number of patrol cars that were observed on this AVL screen?
I have no knowledge of that whatsoever.
Do you know that patrol officers called out for stop sticks in this matter?
I don't know.
What are stop sticks?
Stop sticks are devices that can be deployed to deflate a tire on a vehicle when the vehicle runs over it.
And the Division of Police allegedly has them?
Yeah,
They're hidden someplace, I take it.
I saw them many years ago.
Okay. And from your knowledge in this case, you don't know, well, do you have knowledge whether officers asked for the deployment of stop sticks?
I don't have any knowledge of that from this incident.
Do you know whether or not there were requests made for a police helicopter?
I don't know any of those facts for this incident.
Are you aware that the Attorney General conducted an investigation of this matter?
Yes,
And that the Attorney General's findings was that the Division of Police had a systemic breakdown on the night in question?
I heard that.
Objection.
Sustained.
Lieutenant, when police officers are confronted with the decision whether to get involved in a pursuit, are there issues that come up relative to whether or not they're duty-bound to get involved or whether they should get involved?
Objection.
Overruled.
You're asking if there's issues of whether they're duty bound?
Yes.
What do you mean by that?
Well, it's based on all these events and other events, isn't it a fact that a lot of officers now don't pursue?
I don't know if that's the case or not.
Well, have you heard anecdotal information to that effect?
I have heard that they are less willing to jump in, or they're more concerned about repercussions of getting involved in a pursuit.
Okay. So not only in pursuits, but in uses of deadly force, is there a certain hesitation that officers feel?
I haven't heard that at all.
Okay. Would you agree that if there was, in the area of pursuits, a hesitation or reluctance, you have an officer is pulled in a couple of different directions, right? A duty, a lawful duty to act versus uncertainty as to whether or not he or she should act, correct?
Objection.
Overruled.
I would imagine that I would believe that there is it's not easy to make that decision.
Okay. And that in these matters, we've had a recent prosecution of a Cleveland police officer for dereliction of duty for his failure to come to an aid of another officer in a deadly force incident.
Right, objection? Sustained.
Yes.
Sustained. This witness has established your general proposition, which is that sometimes there could be conflicting obligations.
Well, Your Honor, if I may, the reason why I'm asking that question is that the state is talking about a bunch of officers allegedly being out of control, and I'm just trying to point out that there's a flip side to that. And if they don't act, they're subject to prosecution. And there has been prosecution, Your Honor.
If that evidence is relevant, get it in your case in chief or through a witness with knowledge that's called by the plaintiff.
Okay. If I may have one moment, Your Honor.
Sure. We'll go off the record for a moment. Do you expect Mr. Gutierrez much redirect?
No. Very short. Minute.
That's all I have, Your Honor. Thank you.
Well, hold on, because we've been off the record. You ready? But so we're back on the record. Do you have any more questions, Mr. D'Angelo?
No, Your Honor.
Sir, is permission needed to begin a pursuit? Because I hope that I know the answer. Let me put it to you this way. There is evidence in this case that Officer Vasile Mann began a pursuit on St. Clair between Ontario and West 3rd when a car sped by him and possibly discharged a weapon in the area. He began a pursuit, jumped in his car, he turned around, he tried to follow. Did he need permission to start that?
No, because there's a delay. I mean, you have to engage, realize there's a pursuit going, and broadcast that information and wait for a supervisor to respond. If you broadcast information and wait for a supervisor to respond, that car could be a mile down the road.
Right, okay. And your answer is what I thought it would be. The way I hear your testimony, though, is that everybody after Nan needed explicit permission to get involved. And am I interpreting what you said accurately or not?
That's accurate for policy.
And there is, to my recollection, either already in this case or expect to be evidence in this case that a second car, not Nan's, saw the object of the chase, a Chevy Malibu, going over the Detroit Superior Bridge westbound. I think the second car was either stationary or was going eastbound, but saw the car. And that car joined, well, I'm not sure I should say joined in because Nan might have lost the vehicle by then. But that car began pursuit or entered the pursuit. Did that car need permission?
They need to get permission, but again, they, to watch something go by and not react while you're on the radio trying to get permission from the supervisor is unrealistic. I mean, you need to engage while you're getting permission.
That's what I wanted to clear up. In other words, if you're not in a chase, but the object of the chase either appears in front of you or is maybe so close as to make it impracticable to get permission first, does the policy, or did the policy then allow you to join, but maybe at the same time, or as soon as you could, advise that you had joined and ask for permission to either stay or drop?
The policy never addresses that situation.
Right. Now, where there are cars from multiple districts in any given pursuit, do the cars from one district, in this case, let's say second, have the ability to listen to the radio traffic from first, third, fourth, and fifth?
Well, they've got the car radio and then their portable radios, so you can put a radio on another channel. The dispatcher also has the ability to blend the channels, so they can take one channel. They can merge the channels so that everybody's broadcasting on the same wavelength.
Right. So there is a way to know what the other districts are doing.
Yes. It's not easy, but yes.
And unless you hear over the radio about exactly who's involved and where they are, in a pursuit, particularly if you're the lead or one of the lead cars, do you have another way of knowing exactly who's involved?
If you're a lead car, do we know?
Do you know how many cars are behind you?
It'd be very difficult to keep. I mean, if you're a lead car, second car, you're paying attention to what's going on in front of you and trying to broadcast. It'd be very difficult to consider everything going on behind you as well.
All right, thank you. Do you have any redirect based upon what has been asked since you last inquired, Mr. Gutierrez?
No, Judge, we have no redirect.
I asked some questions. Do you have any recross based on the court's questions, Mr. DeAngelo?
Yeah. Lieutenant, on the question the judge asked you about merging of the radio traffic with districts, whose decision is that to make?
I believe it was. I'm not 100% sure. I believe it was the chief dispatcher's decision to do that.
Okay.
I believe it was so rarely done. I can't even recall ever being successfully done. But
it wasn't done in this case, was it?
I don't know.
Okay. But are you aware that there is a general police order that prohibits the creation of talk groups or merging because of issues with the communication system?
Objection.
Overruled. I mean, it's cross based on a question asked by the courts.
If the policy, I'm not aware of that policy or fluent in that particular
Well,
policy.
in fact, because I want to make sure that the court understands what the reality is there merging of radio traffic between the 2nd and 3rd district coming out in a unified stream through the police communication system?
Objection.
Well, are you asking, is it possible, or did it occur here? Because I know his answer to did it occur here. But are you asking, is it possible?
Is it possible, based on your question, Judge? Because they don't do it, and I think...
Well, again, see, now you're doing the same thing you accuse the other side of. You're trying to get a fact into evidence through saying it. But are you aware of whether it's possible for 2nd and 3rd to merge and be broadcast together?
Only through my experiences, I had the understanding that it was possible. I don't even recall if I've ever seen it done, or I just
Right.
I'm not that knowledgeable.
I heard that. All right, so your next question, if any.
In that respect, are you aware that there are any equipment issues as to whether or not that's even possible with the division's current equipment?
2012 or now?
2012.
No. I'm not aware. The equipment was old, but I'm not sure what the restrictions were.
Since the judge brought it up, if you're from the 2nd District, you're listening on your police radio to 2nd District traffic, correct?
If I'm in the 2nd District, yes.
Okay. And if you have a portable, which a patrol officer should, correct?
Yes.
You can always turn it to another district and try to listen to the radio traffic from that district, correct?
That's possible. You can do that, yes.
Now, if you have lights and sirens going on, and you're trying to listen to the radio traffic from the 2nd District, if you're a 2nd District patrol car, is it difficult to, at the same time, listen to your portable on Channel 3? With all that going on?
The more variables you throw in there, the harder it gets.
And if you're a driver, if you have to add to that the fact that you have to watch where you're going, is that another variable which makes it difficult for the driver to turn on the portable to a different district?
It does make it difficult, yes.
And in that instance, Officer Seifer, he was calling out the pursuit in this case?
Objection.
Are you?
Well, it's sustained. He's already testified to a scant knowledge of the evidence
Okay.
surrounding the events of November 29th and 30th.
On the issue of a passenger in a police car, who broadcasts on police radio, the driver or the passenger?
Passenger.
Okay. If the passenger is calling out a pursuit, is it also difficult to, at the same time, listen to, in this case, 2nd District radio traffic on the police radio, and at the same time listen to your portable on Channel 3 while you're broadcasting on the mic the course of the pursuit? Is that difficult while the lights and the siren are going on at the same time?
Yes, it's difficult.
Thank you, sir.
Actually, we might as well follow up on that. When you talk about radio traffic, in this event, there were some number of cars involved in this pursuit, mentioning things pertinent to the pursuit. Is normal traffic still coming over? You know, a drug dealer on West 25th, a car accident on Lorraine, breaking and entering, that kind of thing?
Hopefully not. But does it happen? Yeah, other traffic gets across that radio that, and usually somebody will yell at them, hey, get off the radio.
Okay. Well, I guess in fairness, I asked a question, Mr. Gutierrez, anything on that?
Well, just one thing. There's a lot of this stuff that the judge and Mr. D'Angelo was talking about going on when you're in a pursuit. Isn't it the responsibility of the supervisors that are outside of the pursuit to manage that pursuit?
Supervisor should be managing the pursuit, yes.
Thank you. No more further questions.
Thank you. Sir, appreciate you coming down here. Your excuse.
Thank you.
We'll go off the record for a moment. Who's your next proposed witness?
Judge, it's Sergeant Fitzpatrick from the 1st District.
In total, would you expect, is this a man or a woman?
Again, I don't expect to be that long.
But even the direct, do you expect it to be longer than 15 minutes?
No.
Okay, well, let's try to, we do need to take a quick break, but of course you guys are going to be done in 15 minutes anyway. Let's go right back on the record at noon and see how much we can get of his testimony. So we're off the record. Some sheriffs, I guess, are meeting the people who are going to be driven on the 18th floor at 12:25. So those who are going to take a ride, be ready at 12:25.